Welcome to Birdsey. In this video, we'll work through exam-style questions, show you what the exam is really testing, and give you clear takeaways to get you ready for exam day. Let's get started!
Let's start with a look at some challenging property ownership and land use control questions. Which type of estate grants the broadest rights of ownership in real property, including the right to sell, lease, or will the property, but is still subject to government powers such as eminent domain and taxation? Is it A, life estate, B, fee simple determinable, C, fee simple absolute, or D, estate et sufferance? The correct answer is C, fee simple absolute. Trap to watch for. Many confuse broadest rights with absolute rights. Even a fee simple absolute estate is subject to government powers, so it is not truly absolute ownership. The correct answer is fee simple absolute, which is the most complete private ownership. If two people hold title to real property as joint tenants and one sells their interest to a third party, what type of ownership does the new owner have with the remaining original owner? Is it A, joint tenancy, B, tenancy in common, or D, community property? The correct answer is B, tenancy in common. Common mix-up. Many assume joint tenancy continues, but selling an interest severs the joint tenancy. The new owner and the remaining original owner become tenants in common, not joint tenants. Which of the following is true regarding a fee simple defeasible estate? Is it A, it may be lost if a specified event occurs, B, it cannot be inherited, C, it is not subject to government powers, or D, it is the same as a life estate? The correct answer is A, it may be lost if a specified event occurs. Why test takers might get tripped up. Fee simple defeasible estates are often confused with absolute estates. The key is that defeasible estates can be lost if a condition is violated, unlike fee simple absolute. Which of the following statements best distinguishes a remainder interest from a reversionary interest in a life estate? Is it A, a remainder interest always returns to the original grantor, B, a reversionary interest is held by someone other than the grantor, C, both interests require the property to pass to the grantor's heirs, or D, a remainder interest passes to a named third party, not the grantor? The correct answer is D, a remainder interest passes to a named third party, not the grantor. What makes this tricky? The terms sound similar, but a remainder interest goes to a third party, while a reversionary interest returns to the grantor or their heirs. Many confuse the direction of future ownership. Which of the following is not a characteristic of tenancy in common? Is it A, each owner has an undivided interest in the property, B, all owners must acquire their interests at the same time, C, interests may be unequal in size, or D, each owner's interest can be sold or willed independently? The correct answer is B, all owners must acquire their interests at the same time. Trap to watch for. Tenancy in common does not require equal shares, but many assume it does. The only requirement is an undivided interest, not equality of shares or time of acquisition.
How'd you do on the first 5 questions? Go ahead and subscribe to Birdsey now and turn your progress into exam day confidence. Ready to jump back in? Let's go.
A property owner grants a friend the right to use a private driveway across her land, but the right is not recorded and is not intended to transfer to anyone else. What type of interest does the friend hold? Is it A, easement appurtenant, B, easement in gross, or D, profit apprendre? The correct answer is C, license. Trap to watch for. Many confuse this with an easement appurtenant or in gross, but because it is personal, unrecorded, and not intended to transfer, it is a license, not an easement. A license is a revocable, non-assignable right to use another's property. Deeds, titles, encumbrances, and easements. A property owner grants a neighbor the right to cross their land to access a public road, but this right is not recorded. If the property is later sold to a third party who has no knowledge of the arrangement, what is the status of the neighbor's right to cross? Is it A, the neighbor retains the right because easements always run with the land? B, the neighbor loses the right only if the new owner objects in writing? C, the neighbor loses the right if the new owner had no actual or constructive notice? Or D, the neighbor retains the right because it was granted before the sale? The correct answer is C. The neighbor loses the right if the new owner had no actual or constructive notice. Trap to watch for. Many assume all easements survive a sale, but unrecorded easements may not bind bona fide purchasers without notice. The correct answer is that the right does not survive if the new owner had no actual or constructive notice. Which of the following is most likely to be considered an encumbrance that does not affect the physical use of the property? Is it A, an easement for a utility company? B, a mortgage lien? C, a restrictive covenant limiting building height? Or D, a recorded right-of-way for a neighbor? The correct answer is B, a mortgage lien. What makes this tricky? Test takers often confuse all encumbrances as affecting use. But a mortgage lien is a financial encumbrance and does not restrict physical use of the property. If a deed is signed by the grantor but not delivered to the grantee, what is the legal status of the title transfer? Is it A, no transfer of title occurs because delivery is required? B, title transfers automatically upon signing? C, title transfers only if the deed is notarized? Or D, title is transferred if the grantee is aware of the deed? The correct answer is A, no transfer of title occurs because delivery is required. Why test takers might get tripped up. Many assume signing alone is enough, but delivery is essential for a deed to be effective. Without delivery, no legal transfer occurs. A property is subject to a zoning ordinance that prohibits commercial use, but the owner has a recorded deed restriction allowing commercial activity. Which rule governs the property's use? Is it A, the deed restriction prevails because it is recorded? B, the owner may choose which rule to follow? C, both rules must be followed only if they are equally strict? Or D, the zoning ordinance prevails because it is more restrictive? The correct answer is D, the zoning ordinance prevails because it is more restrictive. Common mix-up. Many think deed restrictions override zoning, but the stricter rule always applies. In this case, the zoning ordinance prohibits commercial use, so it prevails.
If you want more than just rapid-fire questions, head over to birdsey.ai. You can take unlimited practice exams and get instant help from your personal AI study partner. It's like having a tutor 24/7. Try it free. You'll find a link in the description.
Which of the following best describes the effect of an unrecorded deed between two parties when a third party later acquires an interest in the same property without knowledge of the prior deed? Is it A, the first deed always prevails because it was signed first? B, the third party's interest may prevail if they had no notice of the prior deed? C, both parties share equal rights to the property? Or D, the first deed is void if not recorded within 30 days? The correct answer is B, the third party's interest may prevail if they had no notice of the prior deed. Trap to watch for. Many believe a deed is always valid once signed, but unrecorded deeds may not protect against subsequent bona fide purchasers. The third party's interest can take priority if they had no notice. A property is transferred by a quitclaim deed. but the grantor later discovers an undisclosed easement on the property. Which party, if any, is responsible for addressing the easement's impact on the new owner's use of the property? Is it A, the grantor, because the easement was not disclosed at transfer? B, both parties share responsibility for resolving the easement's impact? C, the new owner, because a quitclaim deed provides no protection against undisclosed encumbrances? Or D, the party who benefits from the easement, since they hold the legal right to use the property? The correct answer is C, the new owner, because a quitclaim deed provides no protection against undisclosed encumbrances. Trap to watch for. Many assume the grantor remains liable for undisclosed issues, but a quitclaim deed offers no warranties. The grantee accepts whatever interest the grantor had, so the new owner bears the risk of the easement. Government powers, zoning, and land use restrictions. A property owner in a residential zone wants to operate a small home-based bakery. The zoning ordinance prohibits commercial use, but the owner claims the business will not disturb neighbors. Which government action would most likely allow the bakery to operate legally? Is it A, applying for a variance? B, requesting a zoning amendment? C, seeking a special use permit? Or D, filing for eminent domain? The correct answer is C, seeking a special use permit. Trap to watch for. Many confuse a variance with a special use permit. A variance allows deviation from dimensional requirements, not use. Here, a special use permit or conditional use permit is needed to permit a non-residential use in a residential zone. A property is currently used as a duplex in an area that has recently been rezoned to allow only single-family homes. The owner continues to rent both units. Which statement best describes the legal status of the duplex? Is it A, the use is illegal and must stop immediately? B, the use is legal as a non-conforming use until it is abandoned or destroyed? C, the owner may expand the duplex without restriction? Or D, the property is automatically rezoned to match its current use? The correct answer is B, the use is legal as a non-conforming use until it is abandoned or destroyed. Why test takers might get tripped up. The key is recognizing the concept of legal non-conforming use, which allows continued use that was legal before the zoning change, but does not grant new rights or immunity from future restrictions. Which of the following is not an example of the government's police power as it relates to land use? Is it A, enforcing building codes? B, imposing zoning restrictions? C, requiring environmental impact studies? Or D, condemning property for a new highway? The correct answer is D, condemning property for a new highway. Common mix-up. Test takers often confuse police power with eminent domain. Police power regulates use, while eminent domain is the power to take property for public use with compensation. A city's comprehensive plan calls for mixed-use development, but the current zoning map designates a parcel for industrial use only. Which statement best describes the legal authority of the comprehensive plan versus the zoning ordinance? Is it A, the zoning ordinance controls unless it is changed to match the plan? B, the comprehensive plan overrides the zoning ordinance automatically? C, both documents have equal legal authority? Or D, the property owner may choose which to follow? The correct answer is A, the zoning ordinance controls unless it is changed to match the plan. What makes this tricky? The comprehensive plan guides future policy, but the zoning ordinance is the enforceable law. Many confuse the plan's intent with actual legal authority. If a city downzones a neighborhood from commercial to residential, which of the following is the most likely immediate effect on existing commercial businesses in that area? Is it A, all businesses must cease operations immediately? B, The city must compensate all business owners. C. Existing businesses become legal non-conforming uses. Or D. Businesses are automatically rezoned to residential. The correct answer is C. Existing businesses become legal non-conforming uses. Trap to watch for. The immediate effect is not forced closure or compensation, but creation of legal non-conforming uses. Businesses may continue operating, but cannot expand or rebuild if destroyed. Agency relationships and fiduciary duties. A real estate licensee is acting as a dual agent in a transaction. Which fiduciary duty is most limited by law in this situation? Is it A. Obedience, B. Accounting, C. Loyalty, or D. Disclosure? The correct answer is C. Loyalty. What makes this tricky? Many assume all duties remain, but dual agency specifically limits the duty of undivided loyalty. The agent cannot fully advocate for either party's interests, so loyalty is restricted by law. Which of the following best describes the relationship between a subagent and the principal in a typical real estate transaction? Is it A. The subagent owes fiduciary duties only to the buyer? B. The subagent owes fiduciary duties to the principal, usually the seller? C. The subagent is not responsible for any fiduciary duties? Or D. The subagent acts as a neutral facilitator with no loyalty to either party? The correct answer is B. The subagent owes fiduciary duties to the principal, usually the seller. Trap to watch for. Many confuse subagent with subbroker or think the subagent represents the buyer. In fact, a subagent owes fiduciary duties to the principal, who is usually the seller. If a real estate agent fails to disclose a material fact to a client, which fiduciary duty has the agent most clearly violated? Is it A. Disclosure, B. Loyalty, C. Obedience, or D. Confidentiality? The correct answer is A. Disclosure. Why test takers might get tripped up. Disclosure and loyalty are often confused. While loyalty is important, failing to disclose a material fact is a direct breach of the duty of disclosure. Which term refers to a person who has been given limited authority to act on behalf of another, typically for a single transaction? Is it A. General agent, B. Universal agent, C. Subagent, or D. Special agent? The correct answer is D. Special agent. Common mix-up. Many confuse special agent with general agent. A special agent has limited authority, usually for one transaction, while a general agent has broader ongoing authority. A real estate broker receives confidential information from a client during an agency relationship. After the agency relationship ends, which duty continues to apply? Is it A. Obedience, B. Confidentiality, C. Loyalty, or D. Disclosure? The correct answer is B. Confidentiality. Trap to watch for. Many think all duties end with the relationship, but confidentiality survives termination. The broker must not disclose confidential information even after the agency ends. Which of the following best describes the duty of loyalty in an agency relationship, especially when the agent is aware of a potential conflict of interest? Is it A. The agent must disclose material facts, but may act in their own interest if the principal is informed? B. The agent must treat all parties fairly and equally, regardless of the principal's interests? C. The agent must put the principal's interests above all others, including their own, and disclose any conflicts? Or D. The agent may act in the principal's interest unless it conflicts with the agent's personal gain? The correct answer is C. The agent must put the principal's interests above all others, including their own, and disclose any conflicts. Trap to watch for. Many confuse loyalty with general honesty. Loyalty specifically requires the agent to put the principal's interests above all others, including their own, and to disclose any conflicts. Simply being honest or disclosing facts is not enough if the agent does not prioritize the principal's interests. In agency terminology, which party is considered the third party in a typical real estate transaction involving a seller, a listing agent, and a buyer? Is it A, the seller, B, the buyer, C, the listing agent, or D, both the seller and the buyer? The correct answer is B, the buyer. Common mix-up. Many assume the third party is always the buyer or seller, but in agency law, the third party refers to the party who is not the principal in the agent's-agency relationship. Here, the buyer is the third party to the listing agent's agency with the seller.
Have you noticed the code in the bottom corner? The next time you're stumped, take that code to birdsey.ai. You'll get immediate help, complimentary study sessions, and access to hundreds of additional questions. It's the best tool to help you pass with confidence.
Listing agreements, disclosure requirements, and agency types. A real estate agent representing a seller receives an offer from a buyer who is not represented by any agent. The agent discusses the buyer's confidential financial information with the seller. Which fiduciary duty is most at risk of being breached in this situation? Is it A, loyalty, B, obedience, C, confidentiality, or D, reasonable care? The correct answer is C, confidentiality. Trap to watch for. Many assume the agent owes no duties to an unrepresented buyer, but the duty of honesty and fair dealing still applies. Disclosing confidential information violates the duty of confidentiality, even if the buyer is not a client. Which of the following best describes a situation where a listing agreement is valid but unenforceable? Is it A, the agreement is in writing but not signed by the seller? B, the agreement is made orally for a residential property? C, the agreement is signed by both parties but not dated? Or D, the agreement includes a commission rate above market value? The correct answer is B, the agreement is made orally for a residential property. What makes this tricky? Test takers may confuse validity with enforceability. An oral listing agreement can be valid in some cases, but is unenforceable in court due to the statute of frauds. If a broker acts as a dual agent in a transaction, which of the following duties is the broker not permitted to fulfill for both parties? Is it A, disclosure of material facts, B, confidentiality of each party's negotiating position, honest and fair dealing, or D, undivided loyalty? The correct answer is D, undivided loyalty. Why test takers might get tripped up. Dual agency allows some duties to both parties, but the broker cannot advocate for one party's interests over the other. So undivided loyalty cannot be given to both. A listing agent fails to disclose a known roof leak to a prospective buyer. Which type of agency relationship, if any, would relieve the agent of the duty to disclose this material fact? Is it A, none, disclosure is always required, B, dual agency only, C, transaction brokerage only, or D, single agency for the seller only? The correct answer is A, none, disclosure is always required. Common mix-up. Some believe certain agency types reduce disclosure duties, but all agents must disclose material facts regardless of agency relationship. No agency type excuses this duty. Which of the following is most likely to create an implied agency relationship, even if no written agreement exists? Is it A, Giving a buyer a list of available properties. B. Hosting an open house for a seller. C. Advising a buyer on how much to offer and negotiating on their behalf. Or D. Handing out business cards to potential clients. The correct answer is C. Advising a buyer on how much to offer and negotiating on their behalf. Trap to watch for. Many think only written agreements create agency, but acting in a way that leads a party to believe you represent them can create implied agency, regardless of paperwork. A seller's agent receives a written offer from a buyer's agent, but fails to present it to the seller, believing the seller would not be interested. Which fiduciary duty is most directly violated in this situation? Is it A. Loyalty, B. Confidentiality, C. Disclosure, or D. Obedience? The correct answer is C. Disclosure. Trap to watch for. Many confuse this with loyalty or confidentiality, but the duty to present all offers relates directly to the duty of disclosure. The agent must disclose all offers to the principal, regardless of personal judgment. Contracts and real estate transactions. If a seller makes an offer to sell a property and the buyer responds by changing the closing date, but agrees to all other terms, the legal effect of the buyer's response is typically considered a counteroffer. This means the buyer's proposed change effectively rejects the original offer and creates a new offer with the only difference being the new closing date. Is it A. It is a valid acceptance and a contract is formed? B. It is a rejection and the seller cannot accept the new terms? C. It is a counteroffer and the original offer is terminated? Or D. It is an invitation to negotiate and the original offer remains open? The correct answer is C. It is a counteroffer and the original offer is terminated. Trap to watch for. Changing any term, even a minor one like the closing date, is considered a counteroffer, not an acceptance. The original offer is terminated and the roles of offeror and offeree switch. A buyer mails an acceptance of a seller's written offer, but before the seller receives it, the seller sells the property to someone else. Which party is bound by the contract at the moment the acceptance is mailed? Is it A. Neither party is bound until the seller receives the acceptance? B. The seller is bound as soon as the buyer mails the acceptance? C. Only the buyer is bound until the seller receives the acceptance? Or D. Both parties are only bound once the buyer receives confirmation from the seller? The correct answer is B. The seller is bound as soon as the buyer mails the acceptance. What makes this tricky? The mailbox rule states that acceptance is effective upon dispatch, not receipt. The seller is bound once the buyer mails the acceptance, even if the seller has not yet received it. A seller promises to keep an offer open for 7 days, but the buyer provides no consideration for this promise. On day 4, the seller sells the property to someone else. What is the legal status of the seller's original promise? Is it A. The seller can revoke the offer at any time before acceptance? B. The seller must keep the offer open for the full 7 days? C. The buyer can enforce the promise in court? Or D. The offer automatically converts to a binding contract after 7 days? The correct answer is A. The seller can revoke the offer at any time before acceptance. Why test takers might get tripped up. An offer can be revoked at any time before acceptance unless consideration is given to keep it open. Without consideration, the promise is not binding. A buyer offers to purchase a property for a certain price, stating that acceptance must be made by email. The seller sends a written acceptance by regular mail before the deadline. What is the effect of the seller's acceptance? Is it A. The acceptance is valid because it was sent before the deadline? B. The acceptance is valid if the buyer receives it before the deadline? C. The acceptance is valid unless the buyer objects to the method? Or D. The acceptance is invalid because it did not comply with the required method. The correct answer is D. The acceptance is invalid because it did not comply with the required method. Common mix-up. When an offer specifies a required method of acceptance, only that method is valid. Acceptance by mail is ineffective if the offer required email. A buyer agrees to purchase a property for a stated price, but the contract does not specify what the buyer will provide as consideration. Is the contract enforceable? Is it A? No, because the contract must state the exact consideration. B. No, because consideration must be paid before the contract is enforceable. C. Yes, because the promise to pay is sufficient consideration. Or D. Yes, but only if the buyer provides a deposit at signing. The correct answer is C. Yes, because the promise to pay is sufficient consideration. Trap to watch for. Consideration must be present, but it need not be detailed in the contract. The promise to pay the price is sufficient consideration, even if not spelled out. If a seller receives an offer to purchase a property and responds by asking whether the buyer would consider a higher price, but does not explicitly reject the original offer, what is the legal effect of the seller's response on the original offer? Is it A, the original offer is automatically terminated? B, the original offer remains open and can still be accepted by the seller? The original offer is converted into a new offer by the seller. Or D, the original offer is suspended until the buyer responds to the seller's inquiry. The correct answer is B. The original offer remains open and can still be accepted by the seller. Trap to watch for. Many assume that any countersuggestion is a rejection, but merely inquiring about better terms is not a rejection or counteroffer. The original offer remains open unless the seller clearly rejects or makes a definite counteroffer. A buyer submits an offer to purchase a property, stating that acceptance must be communicated by phone. The seller mails a written acceptance before the deadline, but the buyer does not receive a phone call. What is the effect of the seller's acceptance? Is it A, a binding contract is formed when the seller mails the acceptance? B, a binding contract is formed when the buyer receives the mailed acceptance? C, no contract is formed because the seller did not accept by phone as required? Or D, a contract is formed only if the buyer later acknowledges the mailed acceptance? The correct answer is C. No contract is formed because the seller did not accept by phone as required. Common mix-up. Test takers may think any form of acceptance is valid, but if the offer specifies a required method, only that method creates a binding contract. Mailing acceptance does not suffice when phone communication is required.
Did you get a different answer? Or maybe you have a question about the exam in general? Drop it in the comments below. We read and answer them personally.
Contingencies, defaults, amendments, and closing procedures. If a buyer fails to deliver earnest money by the deadline stated in the contract, which of the following best describes the seller's options regarding contract enforcement and remedies? Is it A, the seller may immediately terminate the contract and retain any deposits? B, the seller must proceed to closing unless the buyer defaults again? C, the seller must provide written notice and a chance to cure before terminating? Or D, the seller can sue for specific performance without further notice? The correct answer is C. The seller must provide written notice and a chance to cure before terminating. Trap to watch for. Many assume the seller can immediately terminate, but the seller must usually provide written notice and an opportunity to cure before exercising remedies. The correct answer reflects the required notice and cure period. Which of the following best describes the effect of a financing contingency that is not removed by the deadline in a real estate contract? Is it A, the contract is automatically void and both parties are released? B, the party benefiting from the contingency may terminate, but the contract does not end automatically? C. The seller is required to extend the deadline by default. Or D. The buyer forfeits all rights to the contingency after the deadline. The correct answer is B. The party benefiting from the contingency may terminate, but the contract does not end automatically. What makes this tricky? Many believe the contract automatically terminates, but typically the contract continues unless a party takes action to terminate based on the unmet contingency. When an amendment to a real estate contract is signed by only one party and delivered to the other, what is the legal effect of the amendment? Is it B. The amendment is binding on the signing party only? C. The amendment is binding if delivered before closing? Or D. The amendment automatically replaces the original contract terms? The correct answer is A. The amendment has no effect until all parties have signed. Common mix-up. Some think delivery alone is enough, but an amendment is not binding unless all parties sign. The correct answer reflects the need for mutual agreement. If a buyer waives the inspection contingency, but later discovers a material defect before closing, what is the buyer's most likely legal position regarding contract termination? Is it A. The buyer may terminate for any defect found before closing? B. The buyer may demand repairs as a matter of right? C. The buyer may sue for damages and still close? Or D. The buyer may only terminate if the defect was fraudulently concealed? The correct answer is D. The buyer may only terminate if the defect was fraudulently concealed. Why test takers might get tripped up. Waiving the inspection contingency removes the right to terminate for defects found during inspection, unless the defect was fraudulently concealed or otherwise undisclosed. At closing, which party is primarily responsible for ensuring that all contract contingencies have been satisfied or properly waived? Is it A. The closing agent is solely responsible for verifying contingencies? B. The parties to the contract are responsible for ensuring contingencies are satisfied or waived? C. The lender must confirm all contingencies are met before funding? Or D. The real estate broker is required to guarantee all contingencies are cleared? The correct answer is B. The parties to the contract are responsible for ensuring contingencies are satisfied or waived. Trap to watch for. Many assume the closing agent or attorney is responsible, but the parties themselves, usually the buyer and seller, must ensure all contingencies are met or waived before closing. If a buyer and seller agree to extend the closing date after the original contract has been signed, but only communicate this verbally and do not sign a written amendment, what is the legal status of the new closing date under standard real estate contract law? B. The contract is automatically voided due to lack of a written amendment. C. The original closing date remains in effect unless a written amendment is signed by both parties. Or D. Either party may unilaterally enforce the new closing date based on mutual intent. The correct answer is C. The original closing date remains in effect unless a written amendment is signed by both parties. Trap to watch for. Many assume verbal agreements are sufficient, but most real estate contracts require amendments to be in writing and signed by both parties to be enforceable. The original closing date remains legally binding unless a written amendment is executed. Real estate finance. Mortgage loan and financing terminology. A borrower obtains a mortgage loan with a due-on-sale clause. If the property is transferred to a new owner without lender approval, what is the lender's most likely legal right? Is it A. The lender must allow the new owner to assume the loan at the original terms? B. The lender can only increase the interest rate for the new owner? C. The lender may require immediate repayment of the entire loan balance? Or D. The lender must foreclose immediately upon transfer? The correct answer is C. The lender may require immediate repayment of the entire loan balance. Trap to watch for. Many confuse the due-on-sale clause with acceleration for default. The due on sale clause allows the lender to demand full repayment if the property is transferred, not just adjust the interest rate or automatically foreclose. Which statement best distinguishes a promissory note from a mortgage in a typical real estate loan transaction? Is it A, a promissory note creates a lien on the property, while a mortgage is only evidence of debt? B, a promissory note is the borrower's promise to pay, while a mortgage secures the loan with the property. Both documents serve the same legal function in a real estate loan. Or D, a mortgage is not recorded, but a promissory note always is. The correct answer is B. A promissory note is the borrower's promise to pay, while a mortgage secures the loan with the property. Common mix-up. Many think both documents create a lien. The promissory note is the borrower's promise to repay, while the mortgage secures the loan with the property as collateral. If a borrower makes regular payments on a fixed-rate amortizing loan, the portion of each payment applied to principal increases over time. Is it A, it increases with each payment? B, it decreases with each payment? C, it remains the same throughout the loan term? Or D, it fluctuates unpredictably based on market rates? The correct answer is A. It increases with each payment. What makes this tricky? Test takers may assume payments remain constant in composition. In reality, the principal portion increases over time as the interest portion decreases. Which of the following best describes the function of private mortgage insurance, PMI, in a conventional loan? Is it A, it insures the property against physical damage? B, it guarantees the borrower's ability to repay the loan? C, it protects the borrower from foreclosure? Or D, it protects the lender if the borrower defaults? The correct answer is D. It protects the lender if the borrower defaults. Why test takers might get tripped up. Many think PMI protects the borrower. PMI actually protects the lender against borrower default, not the borrower or property. Which term refers to the total amount of interest paid over the life of a loan, expressed as a yearly rate, including certain fees, and is required by federal law to be disclosed to borrowers? Is it A, simple interest rate? B, annual percentage rate? C, loan-to-value ratio? Or D, discount rate? The correct answer is B, annual percentage rate. Trap to watch for. Many confuse interest rate with annual percentage rate. The annual percentage rate, or APR, includes both interest and certain fees, and must be disclosed under federal law. A borrower signs a document that creates a lien on their property as security for a loan, but does not contain the promise to repay. What is this document called in standard mortgage terminology? Is it A, promissory note, B, loan commitment, or D, satisfaction of mortgage? The correct answer is C, mortgage. Trap to watch for. Many confuse the promissory note and the mortgage. The mortgage or deed of trust creates the lien, but does not include the borrower's promise to repay. That promise is in the note. Which of the following best describes the effect of a prepayment penalty clause in a mortgage loan agreement? Is it A, it allows the lender to demand full repayment if the borrower defaults? B, it imposes a fee if the borrower pays off the loan before a specified date? C, it requires the lender to lower the interest rate if the borrower pays early? Or D, it forgives part of the principal if the borrower pays on time? The correct answer is B, it imposes a fee if the borrower pays off the loan before a specified date. Why test takers might get tripped up. The trap is confusing prepayment penalties with late fees or acceleration clauses. A prepayment penalty charges the borrower for paying off the loan early, not for missing payments or default. Foreclosure, equity, amortization, and mortgage markets. If a borrower defaults on a mortgage and the property is sold at foreclosure for more than the outstanding loan balance, what happens to the excess funds after paying off the mortgage and foreclosure costs? Is it A, the lender keeps all excess funds? B, the government claims the excess as a tax? C, the borrower receives the remaining funds? Or D, the real estate agent receives the excess as commission? The correct answer is C, the borrower receives the remaining funds. Many assume the lender keeps all proceeds, but any surplus after paying the debt and costs goes to the borrower. The lender only receives what is owed, not the entire sale amount. Which of the following best describes negative amortization in a real estate loan? Is it A, the loan balance decreases faster than scheduled? B, the loan balance increases because payments are less than the interest due? C, the loan is paid off in equal principal and interest payments? Or D, the borrower pays only interest for the entire loan term? The correct answer is B, the loan balance increases because payments are less than the interest due. Common mix-up. Test takers often confuse negative amortization with interest-only or deferred payment loans. Negative amortization means unpaid interest is added to the principal, increasing the loan balance. In a judicial foreclosure state, which party typically initiates the foreclosure process and files the required legal action? Is it A, the lender files the legal action to foreclose? B, the borrower files to start foreclosure? C, the trustee files the legal action? Or D, the county recorder automatically starts foreclosure? The correct answer is A, the lender files the legal action to foreclose. Why test takers might get tripped up. Some confuse the roles of lender and trustee. In judicial foreclosure, the lender must file a lawsuit. The trustee is involved in non-judicial processes. Which statement about the secondary mortgage market is most accurate? Is it A, it is where borrowers obtain their original mortgage loans? B, it sets the interest rates for all new mortgages? C, it provides down payment assistance to home buyers? Or D, it is where existing mortgage loans are bought and sold between lenders and investors? The correct answer is D. It is where existing mortgage loans are bought and sold between lenders and investors. What makes this tricky? Many confuse primary and secondary markets. A secondary market involves buying and selling existing loans, not originating them or setting borrower terms. If a mortgage is fully amortized, what will the final scheduled payment accomplish? Is it A, it pays only the interest accrued in the final month? B, it pays off the remaining principal and interest, reducing the balance to zero? It leaves a small balance to be paid as a lump sum? Or D, it is typically skipped if the borrower has made extra payments? The correct answer is B. It pays off the remaining principal and interest, reducing the balance to zero. Trap to watch for. Some believe a balance remains or a balloon payment is due. In a fully amortized loan, the last payment pays off all remaining principal and interest, leaving no balance. Real estate valuation and appraisal. Appraisal principles, market value, and comparative analysis. Which characteristic is essential for a sale to be considered a valid comparable in the sales comparison approach to market value? Is it A, the property must have sold within the last 6 months? B, the property must be located in the same city as the subject property? C, the sale must be an arm's length transaction between unrelated parties? Or D, the property must be identical in size and features to the subject property? The correct answer is C. The sale must be an arm's length transaction between unrelated parties. Trap to watch for. Many assume any recent sale qualifies, but only arm's length transactions between unrelated parties without undue pressure are valid comparables. This ensures the sale reflects true market value, not special circumstances. When using the sales comparison approach, which adjustment should be made if a comparable property has a feature that the subject property lacks? Is it A, add the value of the feature to the comparable sale price? B, subtract the value of the feature from the comparable sale price? C, add the value of the feature to the subject property's value? Or D, no adjustment is necessary if the properties are otherwise similar? The correct answer is B, subtract the value of the feature from the comparable sale price. What makes this tricky? Test takers often confuse whether to add or subtract. If the comparable has a feature the subject lacks, subtract the value of that feature from the comparable sale price to align with the subject. Which statement best describes the relationship between market value and market price in real estate appraisal? Is it A, market price can differ from market value if the sale is not typical of the market? B, market value and market price are always identical in a free market? Market value is determined only after a property sells. Or D, market price is always less than market value in a buyer's market? The correct answer is A, market price can differ from market value if the sale is not typical of the market. Common mix-up: many think market price always equals market value, but market price is the actual sale amount, which may differ from market value due to unique circumstances or motivations. Which of the following is not a necessary condition for a transaction to reflect market value? Is it A, both buyer and seller are well informed? B, the property is exposed to the open market? C, neither party is under undue pressure? Or D, the property is newly constructed? The correct answer is D, the property is newly constructed. Why test takers might get tripped up. All options seem important, but market value does not require the property to be newly constructed. It requires knowledgeable parties, open market exposure, and no undue pressure. If a comparable property sold under duress, how should an appraiser treat this sale in the sales comparison approach? Is it A, adjust the sale price upward to account for the duress? B, use the sale but note the duress in the appraisal report? C, exclude the sale from the analysis because it does not represent market value? Or D, average the sale price with other comparables to minimize its impact? The correct answer is C, exclude the sale from the analysis because it does not represent market value. Trap to watch for: it's tempting to adjust the price, but sales under duress should generally be excluded because they do not reflect normal market conditions and can distort the estimate. Which statement best distinguishes market value from market price in the context of a real estate appraisal? Is it A, market value is always higher than market price? B, market price is determined by an appraiser, while market value is set by the buyer and seller? C, market value is the most probable price under normal conditions, while market price is the actual amount paid? Or D, market value and market price are identical if the property is sold within 30 days? The correct answer is C, market value is the most probable price under normal conditions, while market price is the actual amount paid. Trap to watch for: many confuse market value and market price as interchangeable. Market price is the actual sale amount, which may not reflect market value if the sale was not under typical market conditions. Market value is the most probable price under fair, competitive, and open market conditions. Depreciation, obsolescence, and highest, best use. A property is located in an area where zoning has recently changed, making its current use no longer permitted. Which concept best describes the value impact on the property under appraisal principles? Is it A, functional obsolescence? B, physical deterioration? C, external obsolescence. Or D, highest and best use analysis. The correct answer is C, external obsolescence. Trap to watch for. Many confuse legal non-conforming use with highest and best use. The correct answer is external obsolescence, as the zoning change is an external factor that negatively affects value, even if the property can continue its current use for now. When determining the highest and best use of a vacant lot, which factor must be considered first before any other? Is it A, financial feasibility, B, legal permissibility, C, maximum productivity, or D, physical possibility? The correct answer is B, legal permissibility. Common mix-up. Many jump to profitability or physical possibilities, but the legally permissible use must be considered first, since zoning or restrictions may eliminate otherwise feasible uses. A property has outdated electrical wiring that is expensive to replace but still functions. Which type of depreciation does this most likely represent? Is it A, functional obsolescence, B, physical deterioration, C, external obsolescence, or D, economic obsolescence? The correct answer is A, functional obsolescence. Why test takers might get tripped up. The wiring still works, so some may overlook it as depreciation. However, outdated systems that reduce desirability are functional obsolescence, not physical deterioration or external obsolescence. A property is located next to a newly built noisy highway, which has reduced its market value. Which statement best describes this situation in appraisal terms? Is it A, it is an example of curable functional obsolescence, B, it is an example of curable physical deterioration, C, it is an example of incurable functional obsolescence, or D, it is an example of incurable external obsolescence? The correct answer is D. It is an example of incurable external obsolescence. What makes this tricky? The noise is not caused by the property itself, so it is not functional or physical. This is a classic example of external obsolescence, which is incurable and caused by outside influences. Property disclosures, fair housing, and environmental issues. Environmental hazards and property disclosure requirements. A seller is aware of a previous mold problem that was professionally remediated and has not recurred. The state requires disclosure of known material defects. What must the seller disclose to a prospective buyer? Is it A, nothing, since the problem was fixed and is no longer present? B, only if the buyer specifically asks about mold? C, the existence of the prior mold problem and its remediation? Or D, only the remediation, not the original problem? The correct answer is C, the existence of the prior mold problem and its remediation. Trap to watch for. Many assume past issues that have been fixed do not require disclosure. However, most disclosure laws require revealing any known material defect history, even if remediated, because it could affect the buyer's decision. A real estate agent learns that a property is located near a former landfill but has no evidence of contamination. What is the agent's disclosure obligation under typical environmental hazard laws? Is it A, the agent must disclose the proximity to the landfill as an environmental hazard? B, the agent is not required to disclose unless aware of an actual hazard affecting the property? C, the agent must conduct an environmental assessment before listing the property? Or D, the agent should disclose only if the buyer asks about environmental hazards? The correct answer is B. The agent is not required to disclose unless aware of an actual hazard affecting the property. Common mix-up. Many believe proximity alone requires disclosure. However, unless the agent has actual knowledge of a hazard affecting the property, disclosure is not typically required. Disclosure laws focus on known hazards, not mere location. A property built in 1977 is being sold. Which environmental hazard disclosure is most likely required by federal law? Is it A, radon gas disclosure, B, asbestos disclosure, C, mold disclosure, or D, lead-based paint disclosure? The correct answer is D, lead-based paint disclosure. Why test takers might get tripped up. Many confuse the cutoff year for lead-based paint disclosures. Federal law requires disclosure for homes built before 1978, so a 1977 home is included. A buyer's agent is told by the seller's agent that there was a minor oil spill in the basement years ago, which was cleaned up. The buyer's agent does not mention this to the buyer. What is the agent's likely liability regarding disclosure? Is it A, the agent may be liable for failing to disclose a known material fact? B, the agent is not liable because the seller's agent disclosed it? C, the agent is only liable if the buyer discovers the spill after closing? Or D, the agent is not liable if the spill was minor and cleaned up? The correct answer is A. The agent may be liable for failing to disclose a known material fact. What makes this tricky? Some think only sellers are liable for disclosure. However, agents must disclose known material facts to buyers, and failure to do so can result in liability. A seller completes a property disclosure form but omits information about a known underground storage tank, believing it is not relevant since it is unused. Is it A, there is no risk if the tank is not in use? B, the seller may be liable for failing to disclose a material fact? C, the seller is only at risk if the buyer asks about underground tanks? Or D, the seller is protected if the tank is not leaking? The correct answer is B, the seller may be liable for failing to disclose a material fact. Trap to watch for. Many assume unused hazards are irrelevant. However, known underground storage tanks, even if unused, must be disclosed because they may pose future risks or affect property value. If a seller is aware of radon gas in the property, but the state disclosure form does not specifically mention radon, what is the seller's disclosure obligation under general property disclosure laws? Is it A, the seller is not required to disclose radon unless the form specifically asks about it? B, the seller can choose whether or not to disclose radon as it is not federally regulated? C, the seller must disclose the known presence of radon as a material defect, even if the form does not mention it? Or D, the seller only needs to disclose radon if the buyer asks directly about environmental hazards? The correct answer is C. The seller must disclose the known presence of radon as a material defect, even if the form does not mention it. Trap to watch for. Many assume only listed hazards must be disclosed. However, general property disclosure laws require disclosure of all known material defects, even if not specifically named on the form. Radon as a material hazard must be disclosed if known. Fair housing laws, protected classes, and discriminatory practices. A landlord refuses to rent to a tenant because the tenant has a service animal, even though the building has a strict no pets policy. Which protected class is most directly implicated under federal fair housing laws? Is it A, familial status, B, race, C, disability, or D, sex? The correct answer is C, disability. Trap to watch for. Many assume disability is not implicated due to the no pets policy, but federal law requires reasonable accommodation for disabilities, including service animals. The correct answer is disability, not pet ownership or another class. An advertisement for a rental unit states adults only. Which protected class is most likely being discriminated against under the Federal Fair Housing Act? Is it A, age, B, familial status, C, marital status, or D, sexual orientation? The correct answer is B, familial status. What makes this tricky, the phrase adults only may seem neutral, but it discriminates against families with children, which is protected under familial status. Age itself is not a protected class under the Federal Fair Housing Act. A real estate agent tells a client that a certain neighborhood is not suitable for your kind. Which protected class is not directly referenced by this statement under federal law? Is it A, race, B, national origin, C, religion, or D, color? The correct answer is D, color. Why test takers might get tripped up. The phrase is vague and could reference several classes, but unless the agent specifies, color is not directly referenced. The other options are commonly implied in such discriminatory language. Which of the following is not a protected class under the Federal Fair Housing Act, even though it is often confused as one due to state or local laws? Is it A, marital status, B, religion, C, sex, or D, national origin? The correct answer is A, marital status. Common mix-up. Many believe marital status is federally protected, but it is not under the Fair Housing Act. State or local laws may add protections, but federal law does not include marital status. A seller instructs their agent not to show their home to anyone who speaks a foreign language at an open house. Which protected class is most clearly violated by this instruction? Is it A, race, B, color, C, national origin, or D, sex? The correct answer is C, national origin. Trap to watch for. The focus on language might suggest race or ethnicity, but the correct protected class is national origin, as language is closely tied to it under fair housing law. A real estate agent refuses to show a home to a prospective buyer because the buyer is unmarried. Which federal fair housing protected class, if any, is directly implicated by this action? Is it A, sex, B, familial status, C, none under federal law, or D, religion? The correct answer is C, none under federal law. Trap to watch for. Many confuse marital status with protected classes under federal law, but the Fair Housing Act does not include marital status. The correct answer is that no federal protected class is directly implicated, though some states may protect marital status. Real estate math concepts, taxation and property management. Property taxes, proration, commission, and transfer cost concepts. When calculating property tax proration at closing, which party is typically responsible for paying taxes for the period up to, but not including, the day of closing in most standard real estate transactions? Is it A, the buyer for the entire year, B, the seller up to but not including the day of closing, C, the buyer starting from the first day of the month of closing, or D, both parties split the taxes equally for the year? The correct answer is B, the seller up to but not including the day of closing. Trap to watch for. Many assume the buyer pays from the day of closing, but in most standard transactions, the seller is responsible for taxes up to but not including the day of closing. The buyer assumes responsibility starting on the closing day. A listing agent agrees to a commission rate that is lower than the brokerage's standard rate. Who must approve this change for it to be valid? Is it A, the buyer, B, the listing agent alone, C, the broker, or D, the local real estate board? The correct answer is C, The broker. What makes this tricky? Test takers may think the agent can decide, but only the broker has authority to set or approve commission rates. The agent cannot unilaterally change the brokerage's standard commission. If a property is sold and the transfer tax is calculated based on the full sales price, which of the following is true regarding who typically pays the transfer tax unless otherwise negotiated? Is it A, the seller unless the contract states otherwise? B, the buyer in all cases? C, both parties must split the transfer tax equally? Or D, the lender if there is a mortgage involved? The correct answer is A, the seller unless the contract states otherwise. Common mix-up. Many assume buyers pay all closing costs, but transfer taxes are customarily paid by the seller unless the contract specifies otherwise. This is a frequent point of confusion. A property manager receives a commission based on gross rents collected. If a tenant prepays rent for several months, how should the commission be calculated? Is it A, only on the rent due each month as it becomes due? B, on the total rent for the lease term, regardless of payment timing? C, no commission is due until the last month of the lease? Or D, on the full amount of rent collected at the time it is received? The correct answer is D, on the full amount of rent collected at the time it is received. Why? Test takers might get tripped up. Some may think commission is earned as rent is due, but it is typically calculated on all rent collected, including prepayments, at the time the funds are received. Which of the following costs is most likely to be prorated between buyer and seller at closing, rather than paid entirely by one party? Is it A, transfer tax, B, broker commission, C, property taxes, or D, recording fee? The correct answer is C, property taxes. Trap to watch for. Many confuse one-time fees with recurring expenses. Property taxes are typically prorated, while transfer taxes and commissions are usually paid by one party. Lease agreements, tenant rights, evictions, and property management duties. A landlord receives a security deposit from a tenant and places it in a separate account as required by law. The tenant later requests that the deposit be applied to the last month's rent. What is the landlord's duty regarding this request? Is it A, the landlord must apply the deposit to the last month's rent if the tenant requests it? B, the landlord must return the deposit immediately upon request? C, the landlord should retain the deposit until the lease ends and apply it according to the lease and state law? Or D, the landlord can use the deposit for any property expenses during the tenancy? The correct answer is C. The landlord should retain the deposit until the lease ends and apply it according to the lease and state law. Trap to watch for. Many assume a tenant can dictate how the deposit is used, but the landlord is not required to apply the deposit to rent unless the lease or law specifically allows it. The landlord must follow the lease terms and state law, not the tenant's request. A property manager is responsible for handling property taxes on behalf of an owner. If the property is sold mid-year, who is typically responsible for paying the property taxes for the period after the sale? Is it A, the property manager remains responsible for the entire year's taxes? B, the buyer is responsible for taxes after the sale, typically prorated at closing? C, the seller must pay all taxes for the year, regardless of sale date? Or D, the local tax authority decides who pays after the sale? The correct answer is B. The buyer is responsible for taxes after the sale, typically prorated at closing. What makes this tricky? Many overlook that property taxes are usually prorated at closing, making the buyer responsible for taxes after the sale date, not the seller or manager. The manager's duty ends with the sale. A lease agreement states that the tenant is responsible for minor repairs under $50, but the landlord must handle all major repairs. The tenant pays for a $70 repair and deducts it from rent. What is the landlord's right in this situation? Is it A, the landlord can require the tenant to pay the deducted rent and reimburse the repair cost? B, the landlord must accept the deduction since the repair was necessary? C, the landlord must reimburse the tenant for the repair and accept the deduction? Or D, the landlord must split the cost with the tenant? The correct answer is A. The landlord can require the tenant to pay the deducted rent and reimburse the repair cost. Common mix-up. Test takers may think tenants can deduct repair costs, but unless the lease or law allows it, the landlord can require full rent and reimbursement. The tenant overstepped the lease terms. A tenant receives a notice to vacate due to non-payment of rent, but pays the full amount before the eviction process is completed. What is the landlord's obligation regarding the eviction? Is it A, the landlord may proceed with eviction regardless of payment? B, the landlord must return the payment and continue eviction? C, the landlord can keep the payment and evict the tenant? Or D, the landlord must stop the eviction process if the rent is paid in full before completion? The correct answer is D. The landlord must stop the eviction process if the rent is paid in full before completion. Why test takers might get tripped up. Some assume eviction continues regardless, but if the tenant cures the default before the process is finalized, the landlord must halt the eviction unless otherwise specified by law or lease. A property manager receives a request for a reasonable accommodation from a tenant with a disability. The manager believes the request is unnecessary but would not cause undue hardship. What is the manager's duty? Is it A, the manager may deny the request based on personal judgment? B, the manager must grant the request if it is reasonable and not an undue hardship? C, the manager can delay action until the tenant provides medical documentation? Or D, the manager may charge the tenant a fee for the accommodation? The correct answer is B. The manager must grant the request if it is reasonable and not an undue hardship. Trap to watch for. The manager's personal opinion about necessity is irrelevant. If the accommodation is reasonable and not an undue hardship, the manager must grant it under fair housing laws. If a tenant with a fixed-term lease vacates the property before the lease ends and stops paying rent, what is the landlord's primary duty regarding re-renting the property under most state laws? Is it A, the landlord may leave the property vacant and collect the full remaining rent from the tenant? B, the landlord must make reasonable efforts to find a new tenant before seeking unpaid rent from the original tenant? Or D, the landlord can evict the tenant and keep the property off the market until the lease expires? The correct answer is B. The landlord must make reasonable efforts to find a new tenant before seeking unpaid rent from the original tenant. Trap to watch for. Many assume the landlord can simply sue for the remaining rent, but most states require landlords to make reasonable efforts to re-rent the property and mitigate damages before seeking unpaid rent from the tenant. A property manager receives a property tax bill that includes a special assessment for sidewalk repairs. The owner's lease with the tenant states that the tenant pays property taxes as additional rent. Who is responsible for paying the special assessment under most standard lease agreements? Is it A, the tenant is always responsible for all property taxes and assessments if the lease says so? B, the property manager must pay the special assessment personally if the lease is unclear? C, the owner is responsible for the special assessment unless the lease specifically states the tenant must pay it? Or D, the tenant must pay the special assessment if it is billed during their lease term, regardless of the lease language? The correct answer is C. The owner is responsible for the special assessment unless the lease specifically states the tenant must pay it. Why test takers might get tripped up. Special assessments are often confused with regular property taxes, but unless the lease specifically includes special assessments, the owner typically remains responsible for these charges.
Thanks for watching. If you found this exam review helpful, be sure to subscribe for more real-world practice and topic-focused study videos. And visit birdsey.ai to start your free trial of Birdsey, your AI-powered study partner.